main stakeholders. And therefore, in my respectful submission, the system should be selection by a totally neutral body. Now, what that neutral body could be, I have said, one option is the Collegium of the Supreme Court, just as they select judges. The second option is that you can have 3 senior judges of the Supreme Court along with, let's say, the existing Chief Election Commissioner, the Chairman of NHRC or the CAG. I am mentioning these authorities because at least they enjoy functional independence. Today, tomorrow, my lord, after your lordship's direction in this case, assuming that we succeed, the election commissioners will also enjoy independence by way of selection. And once that happens, then of course, my lord, the Chief Election Commissioner can certainly be in the selection committee or the outgoing Chief Election Commissioner, if this selection is of the Chief Election Commissioner, certainly be on the. So therefore, my lord, this would be, in my respectful submission, a neutral body where the male stakeholders do not play any significant role. And that will ensure. The argument is this, my lord. Free and fair elections is a basic feature of the Constitution. Democracy, basic feature of the Constitution. Now, if it is felt by this court, which has plenary powers under 142, that in order to ensure the independence of the Election Commission, it needs to be selected by some independent body, then, my lord, this court has in so many cases given such directions. In the case of police reforms, Prakash Singh. In the case of CBI reforms, Vineet Narayan. In the case of judiciary, Skora. In the case of electoral reforms, that ADR and that PUCL cases, where the court said that, well, in order to have free and fair elections, we need to know the criminal antecedents of candidates. It was not there in any law. But the court said that it is necessary in order to have free and fair elections and transparency in elections, that the candidates' educational qualifications, his criminal antecedents, his assets and liabilities must be known to the people. And therefore the court gave directions, gave binding directions that, look, Election Commission must ensure that this information is obtained on affidavit from all the candidates. Thereafter, the government tried to override that by passing a law saying that, no, this is not required. And that law was struck down in the POCL case as being inconsistent with free and fair elections. So I am saying, my lord, that directions to be issued by this court should not be overridden tomorrow by a law passed by Parliament. Tomorrow they can pass a law saying that, well, government will enjoy complete control over the selection. But that should not override, because these directions are being given to implement the basic structure of the Constitution, to implement the basic feature of the Constitution, which is free and fair elections. Yes. Now, my lord, so I have given the end of what I want. Now, my lord, let me take your lordship through the material. So, first, what happened in the Constituent Assembly? So, my lord, Dr. Ambedkar, at page 2 of the note, your lordship can just take the note because I have quoted almost.
Just seen it actually. You've seen the line of argument in the material.
Yes.
So, Bangla, Saxena, the exchange between them.
Yes.
And what are Dr. Ambedkar. So, you've seen it.
So, should I read it or I don't know what that is?
You've seen it. Put it in your room.
That's very good. So,
Go ahead.
yes. Page 2 of the note, Lord, Dr. Ambedkar presented an amendment in Article 289(10) of the Constitution, of the proposed Constitution. The amendment vis-à-vis the appointment of Election Commissioner was as follows. The Election Commission shall consist of the Chief Election Commissioner and such other election commissioners, if any, as the President may from time to time appoint, and when other election commissioner is so appointed, Chief Election Commissioner shall act as Chairman of the Commission. Dr. Ambedkar, while presenting the amendment, said the House will remember that in a very early stage of the proceedings before the Constituent Assembly, a committee was appointed to deal with what are called fundamental rights. The committee made a report that it should be recognized that the independence of the elections and the avoidance of any interference by the executive in the elections to the legislature should be regarded as a fundamental right and provided for in the chapter dealing with fundamental rights. When the matter came up before the House, it was the wish of the House that while there was no objection with regard to this matter as of fundamental importance, it should be provided for in some other part of the Constitution and not in the chapter dealing with fundamental rights. But the House affirmed without any kind of dissent that in the interest of purity and freedom of elections to the legislative bodies, it was of the utmost importance that they should be freed from any kind of interference from the executive of the day. In pursuance of the decision of the House, the drafting committee removed this question from the category of fundamental rights and put it in a separate part containing articles 289, 290 and so on. Therefore, so far as the fundamental question is concerned that the election machinery should be outside the control of the government, there has been no dispute. What Article 289 does is to carry out that part of the decision of the Constituent Assembly. It transfers superintendence, direction and control of the preparation of electoral rolls and of all elections to Parliament and the legislatures of the state to a body outside the executive to be called the Election Commission. This is the provision contained in subclause 1. Then, my lord, Dr. Shippan Lal Saxena raised reservations about the appointment of the Election Commission. Dr. Ambedkar addressed the criticism of Mr. Saxena and conceded that his provision, that is appointment of election commission by president, does not contain anything to provide against nomination of an unfit person to the post of chief election commissioner or any other election commissioners. In order to overcome the objections of Dr. Saxena, Dr. Ambedkar added, subject to the law made by Parliament in draft Article 289, observing, quote, because, as I said, it is going to be one of your greatest headaches, and as a via media, it was thought that if this assembly would give or enact what is called the instrument of instructions to the President and provide therein some machinery which it would be obligatory on the President to consult before making any appointment, I think the difficulties which are felt as resulting from the American Constitution may be obviated and the advantage which is contained therein may be secured. At this stage, it is impossible for me to see or anticipate what attitude this House will take when the particular draft instructions come before this House. The House rejects the proposal of the drafting committee that there should be an instrument of instructions to the President which might include, among other things, a provision with regard to the making of appointments. This problem would then be solved by that method. But as I said, it is quite difficult for me to anticipate what may happen. And therefore, my lord, the final